Here's a scenario I would like for you to think about. Your parent has an emergency. They're in the hospital, they're unconscious, or cannot communicate. They still have bills to pay. There are financial decisions that cannot wait, like the mortgage, insurance, bank accounts, all need to be managed. Can you do any of it? If your parent does not have a durable power of attorney in place and you're not named in it, the answer is probably no. Without a durable power of attorney in place, one of the few options is court. Going through the court system, hiring an attorney, and it taking weeks, sometimes months, to get legal access to your parents' financial accounts and information. And in the meanwhile, while you go through this process, everything's on hold. This is not a scare tactic. This is what happens to families who do not have the proper documentation in place when an emergency occurs. Welcome to the Sandwich Generation Life. This channel is for adults raising their children while also caring for aging parents. Today, I'm going to explain exactly what a durable power of attorney is, why it is an important document for families to have, and what you need to do to get one in place. So, before I go any further, however, I would like to make this clear. I am not a lawyer or a legal advisor. Everything in this video will be for general informational purposes only, based on my own experiences and research as a sandwich generation caregiver. Laws around power of attorneys vary by state. Every family situation is unique. Please use this video as a starting point and work with a qualified estate planning or elder law attorney to make sure you put everything into place that's right for you and your family. With that said, let's get started. A power of attorney is a legal document that gives one person, called the agent or the attorney in fact, the authority to act on behalf of another person, called the principal. And the agent is usually you, and the principal is the parent. So when a parent signs a power of attorney, naming you as the agent, they are legally authorizing you to make certain decisions on their behalf. Now, there are different types of power of attorneys. The differences matter, so I would like to walk you through those types of power of attorneys. First, there's a general power of attorney. A general power of attorney gives broad authority to the agent, managing finances, signing contracts, handling real estate transactions, managing investments. It's a wide-ranging power of attorney. But here's the critical limitation. A general power of attorney is only valid while the principal's mentally competent. The moment that your parent becomes incapacitated, which is often exactly when you need this authority, a general power of attorney automatically ends. So let me say that again, because it is the thing that catches families off guard. A general power of attorney becomes invalid at exactly the moment most families need it most. So just be careful with this one. Next, the durable power of attorney. This is where the word durable becomes everything. A durable power of attorney contains specific language stating that the document remains in effect or becomes effective even if the principal becomes mentally incapacitated. That one word, durable, is the difference between having legal authority when your parents need you most and having no authority at all. Next, there is also a third type called springing power of attorney. This is a document that only activates under specific conditions. Typically when the principal is determined to be incapacitated using required documentation from one or more physicians. The advantage is that the parent retains full control until they truly cannot make their own decisions. The potential challenge is that activating a springing POA in a real emergency can take time that families sometimes don't have. For most families caring for an aging parent, a durable power of attorney that is active immediately upon signing is the most practical choice. But this is exactly the kind of decision where an attorney's guidance based on your specific situation is invaluable. I want to paint a very clear picture on why this matters. For most families, it is hard to feel the urgency until you're in the middle of the crisis. And of course, that is then too late. Here is what having a durable power of attorney allows you to do for your parent. You can pay the bills, manage bank accounts, handle their mortgage or rent payments, deal with the insurance company, file their taxes, manage investments, handle real estate transactions if needed, and sign legal documents on their behalf. In short, you can keep their financial life running even when they are unable to do so. And here is what happens without it. So I talked a little bit about this earlier. Even if you are an adult child, even if you've been helping your parents with their finances for years, even if everyone in the family knows and agrees that you are the right person to handle these things, without a durable power of attorney, you have no legal authority. Banks will not talk to you. Financial institutions will not release information. You cannot sign a document on their behalf. You cannot manage their accounts. To gain legal authority without a POA in place, the only option is usually court, to go through the court system, which means you'll have to seek something like a guardianship or conservatorship. You'll have to get an attorney. You'll have to pay attorney fees and court fees. Then you'll have to go through a long process of court hearings that could, again, like I mentioned earlier, take weeks or months. And all during this time frame, the finances of your parents are going to be on hold. My story around power of attorneys, I did what you should not do. I went online, I Googled the power of attorney for the state that my parent was in, got a template and read through it. So I went with that and got it signed, and it was notarized, and there was a witness and all that. So long story short, that's my POA story. So this document is not about anticipating the worst. This document is making sure that when the worst occurs, you're covered. So let's talk about the agent, the person named in the durable power of attorney, and what the role actually involves. So we talked a little bit about some of the things that the agent can do, like, pay the bills and things like that. How do you go about naming an agent? So typically, the agent is someone that your parent trusts, because after all, the parent is going to give over all their account information, all their bill information to this person, and trust that they're going to pay the bills like they're supposed to. So it should be someone who is organized and responsible, someone who can handle financial decisions under pressure, and someone who will act on your parents' best interest, not their own. This is often a adult child, a trusted friend, a financial professional. If your parent has concerns about naming a family member, there is an institutional fiduciary, a professional who manages these responsibilities for a fee. So this is also an option. And it is also wise to name a successor agent, a backup person, in case the original agent cannot perform their duties. We're going to go into talking about what an agent can do. Specific powers depend on what's written in the document. A broad, durable power of attorney typically allows the agent to do, some of the basic things we went over earlier: managing accounts and financial institution information, paying bills and debts, filing tax returns, buy, sell, or manage real estate, manage investments, retirement accounts, apply for government benefits on behalf of the principal, handle insurance matters, make charitable donations within the limits of the documentation. What an agent cannot do. So even though the durable power of attorney has broad powers, the agent cannot change a will. That's a big one. The agent cannot make healthcare decisions. There is a separate healthcare power of attorney that I'll be talking about in the next video that will explain the differences between the two types of power of attorneys. An agent cannot act after the principal's death. At that point, the will is in effect, and whoever the executor of the will take over. So it is also critical that an agent is acting on the principal's best interests. A durable POA, and POA just stands for power of attorney. It's not a blank check. If they misuse their powers as an agent, there can be legal consequences around that. This is why the choice of agent is one of the most important decisions in this entire process. Choose someone who has integrity, that you would bet everything on, because they have a very real sense of who you are. When you can no longer speak, they would be making decisions on your behalf as if they were the principal, if they were the parent. So it's good that they know you. So now let's talk about how to create a durable power of attorney. Let me walk you through the process. So I remember earlier I told you I did the fancy Googling to find the actual power of attorney template document out there for the state that my parents in. I don't recommend that. Your first step should be talking with an attorney, either an estate planning or an elder law attorney. That's always going to be the best bet. Here's why I suggest that you use a lawyer, because the language in the POA matters. There are financial institutions that require certain language in a POA, and if it's not in there, they're rejected. So of course you want the wording to be in there correctly. Then of course there's language specific to the state that also needs to be in the documentation, so that comes into play with having an attorney on board as well. So the second thing, know your state's requirements. These requirements are around how you sign the POA. So some states require you to sign, the principal will sign the document in front of a notary so that the document is notarized. And there must be one witness, or it could be that they require two witnesses. And typically, whenever you're signing documents with witnesses and it's something to do with family situation, you want to make sure the witnesses are not family members. That's usually the best way to go about that. So that's another reason why you need to consult with an attorney, because they'll let you know all of this information so you won't be caught off guard. Step 3, be specific about the powers granted. So remember earlier I was talking about how broad the powers are of a durable power of attorney, just a basic one, because it talks about maybe you having power over all real estate transactions. Well, that's really broad. And maybe the principal, the parent, does not want you to have all that broad authority. So they can work in conjunction with the lawyer to put language in the power of attorney to restrict it. Step number 4, execute it properly. The principal must be mentally competent to sign a POA of any type. It's non-negotiable. So if you wait too long to get this durable power of attorney in place, your principal is somehow incapacitated, it's too late, and your only option will be to go to the courts. So you definitely want to make sure you get this in place when everyone's healthy and when they're capable. Step 5, you want to notify relevant institutions. Looking back, I probably should have done that right away so that there was no issues. There's caveats involved with the power of attorney. So even when you have a power of attorney, there are some companies, some institutions that will not accept the power of attorney. They have their own document, like federal and state agencies. So those documents that they have you fill out gives you permission to talk on behalf of your parent. And it also has to be signed by a competent parent. So you have to be really careful here, because dealing with the Social Security Administration or pensions. So even though you have that power of attorney, you've got it in place years ago, if there's any federal or state agencies involved, make sure you call them and get all the information about what they're going to need for you to officially take over your parents' accounts. Let's go into the hard part. What if your parent resists creating the power of attorney? That can be very difficult, but it's important not to be angry with them or to push it. If they don't want to do it right then and there, leave it alone, and maybe try to understand where they're coming from. The fact that, they're used to being so independent, and power of attorney in itself means that if it's in place, they no longer have that control. So what you can do is just back away, come back maybe a few months later, a few weeks later. And the good thing about this is that you plant the seed. Just come back to it. You don't have to force the issue if they don't want to discuss or create the durable power of attorney at that moment, at that time. So once you have everything in place, you have everything signed, you're good about all that's in the document, you want to make sure the original copy is stored in a safe, accessible place. So whether that's a fireproof safe, that's a safety deposit box, that's with the attorney, you want to make sure the agent knows where that document is located. Also, you can get certified copies from the attorney. This is where it's needed, because some financial institutions, some companies don't want a copy of the original. They want a certified copy. So just make sure you have a few copies available in case that happens. And review the POA. The standard is that you should review it every other year. You want to make sure that everything is still accurate. Make sure you look at the agent. Maybe the agent passed away. Maybe the agent decided they don't want to do it anymore. Whatever the situation may be, you want to look through the document to see if there may be changes that need to be made. Also, there are other documents that work together alongside the durable power of attorney, and those documents are the will, which I talked about in the last video, and I'll make sure and put a link in the description of this video. And then, of course, the durable power of attorney, the medical power of attorney, and the medical directive. And I'll have videos in the coming weeks around the health care power of attorney and the health directives. So just make sure you subscribe so that you'll get notified of those videos when they become available. So now here's what I would like for you to walk away with today. Durable power of attorney is not for worst case scenarios. It is a document for the unexpected. So it's always good to have in place. It's your parent's way of saying, I trust this person to speak on my behalf. If the parent does not want one in place right now, make this the next thing you do. Maybe wait a couple of months and see if you can get them to create one. If this video helped you, please share it. If you know anyone going through this right now, please share it. If you have any comments, that your parent have a durable power of attorney in place, are you the agent? Please put that information in the comments below. Tell me all about it. I read every comment. Please click the like button. Please subscribe so you can get other helpful videos of coming weeks. Thanks.